is compelling and persuasive. To take the words of the court, it is convincing. It provides a strong foundation for the court to reach conclusions on the facts and to find that the Rohingya genocide is clearly established. Mr. President, members of the court, I've addressed the existing legal standards for proving genocide under the 1948 Convention in general terms, including proof of dolus specialis. These standards build directly on the approach set forth by Raphael Lemkin in his book, Axis Rule. And so I'm going to conclude by returning to where I began. New conceptions require new terms, Lemkin wrote in November 1944. He noted in these pages the evolution of international law having brought about a considerable interest in national groups, as distinguished from states and individuals. He invented the concept of genocide to deal with that evolution. And by genocide, he wrote, we mean the destruction of a nation or of an ethnic group. This occurred, he continued, as a composite of different acts of persecution or destruction. And on his interpretation, they occurred in two phases. One, these are his words, destruction of the national pattern of the oppressed group. The other, the imposition of the national pattern of the oppressor. And he continued, the oppressed who were the subject of genocidal acts could remain or they could be removed. The oppressed were always members of certain national groups who lived as minorities. And I quote him, if these groups should not be adequately protected, such lack of protection would result in international disturbances, especially in the form of disorganized emigration of the persecuted who would look for refuge elsewhere. End of quote. And against this background of what he saw between 1933 and 1945, he proposed, quote, an international multilateral treaty should provide for the introduction of provisions protecting minority groups from oppression because of their nationhood, religion, or race. The 1948 Convention is that international multilateral treaty. And Lemkin's words, written in 1944, and Article 2 of the 1948 Convention capture, regrettably but exactly, what has happened to the Rohingya. Lemkin's assessment back in the 1940s was the product of a meticulous exercise of research and reflection. His book and the Convention are testament to the power of ideas, to their reduction into a written and legal form, and to their capacity to hope for the world as a better and safer place. Raphael Lemkin lived through terrible times, just as the Rohingya have. But at no point did he, or his colleague Hirsch Lauterpacht, or so many others like them, choose to curl up in a corner and weep, or conclude that action or international rules were pointless. And the Rohingya have adopted exactly the same approach. And so has the Gambia, whose Attorney General you heard from this morning. That is why the Gambia is here today. Mr. President, the Genocide Convention, including its Article 2, really matter. And so does its meaningful and effective interpretation and application on the facts of this case to the situation regarding the Rohingya. It's to that issue that Mr. Reichler will now turn, and perhaps after a brief pause, you would call him to the bar. I thank you for your attention.
I thank Professor Sands. Before I give the floor to the next speaker, the court will observe a break of 50 minutes. The hearing is suspended.